Good morning, and I'd like to thank you on behalf of my colleagues for your appearance here today. Let me start with a personal observation, and that is that those who are vigilant in protecting our constitutional rights and civil liberties against overreaching in times of national crisis are every bit as patriotic as those who favor more extensive incursions in the name of national security. Perhaps even more so because they are courageous in the face of what seemed to be a popular demand. Something terrible happens, the cry is, we've got to do something different. I would suggest that we did in fact have the tools available prior to 9/11, given the information we had there been a greater focus on the threat of terrorism within the United States. On the one hand, we know that we had within our intelligence community a communication to suggest that Al-Qaeda was going to strike within the United States and was going to use commercial airliners. On the other hand, we had intelligence that involved the identification of two members of Al-Qaeda who we knew were within the continental United States. And I would suggest that had this information been pursued, we certainly could have found the two individuals. The FBI had no restriction, even if they did not have the means themselves, from using private organizations which conducted data mining at the time. And there are a number of individual companies to which the FBI would have had access had they focused specifically on this. Of course, we're dealing with 2020 hindsight, and we're all mindful of that. But when we discuss making wholesale changes in our civil liberties and protections of privacy, we have to keep in mind the effects of that on the body politic, on the public, where there is a tremendous apprehension now about individuals' civil rights and civil liberties being subject to more and more increasing government intrusion, and particularly in connection with the enormous amount of effort that is now going into data collection, data mining by various agencies of the government. And although we have heard this morning some quotes from the Israeli Supreme Court, and I think properly so from our other panels, since the Israelis face in their democracy an enormous challenge, one that we could not begin to comprehend in this country, even with the 9/11 tragedy on a daily basis in that country, and yet the Supreme Court's reaffirmation of the separation of power and the rights of individuals has been, and presumably will continue to be, of major concern and protection. Going to our own Supreme Court, let me quote from two members, one a present and one a former member. In 1995, Justice Sandra Day O'Connor warned, "It can never be too often stated that the greatest threats to our constitutional freedoms come in times of crisis." And Thurgood Marshall, who in 1989 warned, "History teaches us that grave threats to liberty often come in times of urgency, when constitutional rights seem too extravagant to endure." The World War II relocation camp cases, the Red Scare of the McCarthy era, internal subversion cases are only the most extreme reminders that when we allow fundamental freedoms to be sacrificed in the name of real or perceived exigency, we invariably come to regret it. Let me ask about the issues of data mining. Mr. Baker, you've mentioned the TIA, and which was at first called Total Information Awareness, and when a great furor arose about the name of that project, they changed it to Terrorism Information Awareness. But notwithstanding that, and notwithstanding Admiral Poindexter's dismissal from that position, which I think on balance was not all that controversial given what was going on, the Department of Defense has nevertheless continued to examine and expend significant resources on data mining. I'd like to ask the question of this panel as to how many different agencies in the United States government are now in the process of amassing extensive, exhaustive data collection databases for utilization under different scenarios. Clearly, we have the Department of Homeland Security, which through its various agencies, including the Coast Guard and Naval Investigative Service, have indicated that perhaps contrary to the initial conception of the Department of Homeland Security's function, it is not a passive consumer of intelligence, but is in the business now of actively collecting data. There is ICE, the Immigration and Customs Enforcement Agency. There is, of course, the FBI. There is TTIC. There are various state agencies that are combining to have regional data mining through various private companies accessible. My question is how many different agencies are now collecting this information, and is that the right way to go about business? First, Ms. Miller.
I don't know how many agencies are collecting this kind of information right now, Mr. Ben-Veniste. This commission may have a better take on that than we do, actually. But the point of my earlier comments and the testimony I submitted is that there probably is a better way. I mean, without trying to sort of repeat what the Markle Foundation Task Force report most recently said, I mean, I think we agree that it made some sense to have DHS be in the lead. I think that there's some confusion that's developed between the missions put forward under the executive order for TTIC versus DHS, as an example. But more important than anything is that, you know, is a view that I share, which is that what you want to do if you're going to use this information is not have it focused just in the federal government and sort of driven by traditional views of how you gather data, which is, I think, what has been going on with the FBI and even TTIC. And instead, you should take a step back and try to figure out how you want to have an enabled distributed network that can support decision-making and analysis across this country in an effective way with privacy guidelines in place. And that matters, because if you are, you know, as you've said, data mining, or data analysis, is going on in the private sector right now. It goes on, I presume, in some instances in the federal government right now. It can be very both powerful and can lead sometimes to wrong results, and that's why you need to have guidelines about how you use it. I mean, the sort of two categories of data analysis that people typically talk about are subject-driven and pattern-driven. And subject-driven, you just look to a person often and then say, all right, let's find out everything that person does. It's very much like law enforcement, but driven by more powerful tools. And if you've got the right person, it at least allows you to focus in on that person more effectively than we have been able to do in the past. Pattern analysis is very different. We're not all that good at it yet. We don't have the technology, as I understand it, really to do it well. But if we do have it in place as technology matures to do it well, you can still end up with horrific results, not just in terms of coming to the wrong result occasionally as opposed to the right result. And I think you need to build a technology that takes those issues into account and has executive branch oversight, and so that you do not go through a kind of an ad hoc, every agency that feels like it wants to do this just goes out and tries to do it. That is not a good idea.
What restrictions are there on various agencies creating their own stovepipe data mining and collection?
Well, there's some restrictions that came about as a result of TIA with respect to Defense Department funding, as I understand it. And I suppose that is an example, frankly, that would be out there, at least to some other agencies, to give them pause if they do things without thinking about an integrated approach to this that I've been trying to describe. But absent either, I would not urge legislation, at least as the first step, because I think that's a somewhat, blunt instrument for dealing with these issues, but it does require effective, active, thoughtful thinking and actual rulemaking within the executive branch. And if that's going on, it's not visible to the outside world.
Well, let me follow up on your observation with respect to TIA and the Department of Defense. I think it has been little publicized, but nonetheless important that we learn that NORTHCOM, the Department of Defense domestic protection agency, if you will, of the Department of Defense, which now has a definite domestic mission, is in the process of creating, through its command at Peterson Air Force Base in Colorado Springs, Colorado, a combined intelligence and fusion center, where it has let out contracts for the creation of what they call actionable intelligence about a domestic terrorist threat, collecting and analyzing data from 50 different federal, state, and local agencies. Supposedly, NORTHCOM does not collect data on its own, but rather it analyzes and then disseminates data. What is the proper role of the United States military in this exercise as another of these entities creating, analyzing, disseminating data on United States citizens?
Well, that's a big question. Let me just maybe take one or two bites at it. Northern Command is not necessarily a structure that I would have put in place if I were sitting at the Department of Defense, but I understand why Secretary Rumsfeld and the President decided to do that, because there needed, I think they felt, to be more structure and focus within the U.S. military on domestic sort of protecting us largely from catastrophic consequences of a successful attack, as opposed to necessarily going out there and stopping the attack before it happens. I think that if you, in any military command, you have an intelligence fusion center. They don't know how to do it any other way. I think, at least as I understand it, Northern Command has been set up, as you said, so that they are not collecting intelligence actively, but simply, getting the products of other
Buying it,
agencies.
as it were.
Getting it from other federal agencies for the most part. And I think it's a work in progress. I think that although it's a different subject than the one we sort of started out with here today, I think that there is going to need to be a lot of hard thinking and guidelines put in place with respect to that entity. Not that I expect it to do something that would not make us proud, but I think it's a new area for the military in today's world. And some of the same concerns that came up in law enforcement with the wall, so-called wall, will come up with Northern Command. They're going to get feeds from all the joint combatant commands all over the world, and they're going to mush it together with a lot of domestic intelligence, I would expect, and they need guidelines for what they do with that information. And I think they're in the process right now of working it out, but oversight on that front is appropriate too, because my own view is that the last thing we want is to have the U.S. military, which I think is so respected in this country, lose some of that respect if it's perceived as sort of crossing a line into law enforcement and sort of surveillance of Americans, which I don't expect them to do, but I think we need some sort of guidelines in place to make sure that people are reassured that that's the case.
I agree with you. Mr. Baker, do you have some additional agencies which you know about who are also in the data mining business?
No, I don't. I'm assuming that most of them have been brought to light in the intense coverage looking for precisely that in the last 6-8 months. My sense, in fact, is that as that coverage has intensified and as the climate in the country has changed, that many people who had considered that, many agencies who had considered that, are slowing or stopping their efforts to use information in ways that might help us to find terrorists, responding mainly, I think, to theoretical concerns about ways in which privacy abuses could occur, not to actual privacy abuses. I think after September 11, the lesson from the wall and the well-meaning basis for creating that is that you better be pretty cautious before you say, in order to avoid some theoretical risk, I'm going to put in place real limits on what people can do to protect us. I am, however, very big on some of the technologies that would allow us to audit access to databases. There's very powerful technology that can impose a lot of accountability on people who do that. If we find actual abuses, that we ought to take action then. I think a process of trying to write the rules in advance, as the wall has demonstrated, is bound sooner or later to create a disaster.
Let me follow up on your observations with respect to pre-9/11, which I think differ from mine. What was there about the information that we had in our possession that would have precluded the FBI working with the FAA to put the two individuals whom they were looking for on a no-fly list, given the fact that we know that they were using their correct names and identification, and given the fact that we at least had some warning that some terrorist act involving commercial airliners was being planned?
I think that is a possibility that could have been done. There was bad coordination and stovepipes throughout government. Part of that, however, was reflected in an inability for information technology systems to interoperate.
Well, I'm not talking about it.
That agent did what he thought was the right thing, which was to try to locate these folks using the tools he had ready access to. It didn't work.
What we're talking about, what was available. And I'm not talking about interactive anything. I'm talking about somebody picking up the telephone, calling the FAA, saying there's two people who ought to be on a no-fly list.
He was trying to find them. We weren't actually focused, obviously, on exactly what happened on September 11. He was trying to find them, not keep them off of planes. If they'd been turned away on a plane, I wouldn't be surprised if he thought to himself, if we turn them away, they'll know we're onto them and we'll never catch them. I don't know what was going through his head, but that's certainly a possibility.
Well, being identified at an airport and being released and, quote, turned away are two different things. Mr. Rotenberg, could you address the first question in terms of the number of agencies, to your knowledge, that are in the data mining business?
Well, Mr. Ben-Veniste, again, I think some history is relevant here because, you know, for more than 30 years, we've had a large decentralized, computerized criminal history system in the United States called the National Crime Information Center. And that database is available, I think, to over 800,000 individuals in the law enforcement community. The information that's in that database has continued to expand over time, including material witnesses and others. It is already a powerful tool for when a person is detained to determine if there's an outstanding warrant. Now, data mining, as I suggest in my testimony, raises a different set of problems because it is an attempt to integrate information from different data sets that aren't naturally related. I mean, to use sort of a trivial example, in the commercial realm, if you have purchased a sweater around Christmas time for the last 2 years, the merchant is probably making a wise move in suggesting to you this year around Christmas time, perhaps you'd like to purchase a sweater. But you can make that extrapolation because you're dealing with similar data to produce a conclusion. A lot of the data mining projects that were pursued under TIA and are now still being proposed for CAPS attempt to suggest that you can take information from financial institutions and information from travel agencies and information from communication carriers and extract and infer conclusions. And I think that is a much more difficult problem. I think it would be a mistake to assume a correlation between the level of data mining that occurs and the level of useful information that is produced.
Let me ask you whether, in connection with the military's involvement in analyzing the information to which it is gaining access throughout the world and with respect to United States citizens, whether you see a tension between the Posse Comitatus Act and the new involvement of the military in collecting this information.
Right. I haven't thought so much about that problem, but I will tell you that your question just a moment ago made me think of a famous Supreme Court case prior to the passage of the Privacy Act, which was Laird versus Tatum. And the issue in that case concerned the collection of information on war protesters by the Department of Defense. And they alleged a Fourth Amendment violation, saying that this information was being collected without any judicial oversight. The court ultimately found against them because they couldn't find an actual harm. But it was suggested by the court at that point in time that you could imagine a more elaborate system of surveillance that would raise significant Fourth Amendment concerns. And, you know, I have to say, somewhat in response to some of the comments that Mr. Baker has made this morning, I don't think adherence to Fourth Amendment standards is a theoretical concern. I think it is an underlying goal and obligation of the federal government. And many of these systems that are being discussed raise significant Fourth Amendment issues as to their application.
Thank you. Mr. Chairman.